All rise, veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer les fonctions résiduelles des tribunaux pénaux est ouverte. Please be seated.
Good morning, everyone. Good morning, Mr. Kabuga. We are here today following the Appeal Chamber decision of the 7th of August, which affirmed the trial chamber's determination by majority that Mr. Kabuga is not fit for trial and is very unlikely to regain fitness in the future. As a consequence of that determination, the Appeals Chamber, noting the trial chamber's organic familiarity with the case and the medical monitoring regime, remanded the matter to the trial chamber with the instruction to impose an indefinite stay of proceedings and to determine the modalities of such a stay. The appeals chamber also instructed the trial chamber expeditiously to address the issue of Mr. Kabuga's detention on remand and to consider appropriate modalities and conditions for his release. The purpose of today's hearing is to obtain the views of the parties on these key issues, as well as to allow the parties to raise matters relevant to a status conference under Rule 69. Before we begin that process, however, I note that Mr. Kabuga is appearing today via video conference link, and it has been confirmed to me that he is receiving interpretation in the Kinyarwanda language. Yesterday, the parties and the trial chamber had a case management meeting to focus today's discussion. The trial chamber had scheduled today's hearing for early September so that these key issues could be considered with the benefit of the latest joint report from the 3 independent medical experts, which was received by the trial chamber on 31st August. The experts, consistent with their last report, agreed that due to a slowly progressive and irreversible dementing illness, Mr. Kabuga continues to lack 4 capacities necessary for meaningful participation in a trial, namely the ability to understand the course of proceedings, understand the evidence, instruct counsel, and testify. They agreed that at a superficial level, he retains the capacities to enter a plea, understand the nature of the charges, and understand the consequences of the proceedings. The experts further agreed that on the balance of probabilities, Mr. Kabuga's mental capacities will not improve in the future to such an extent that he will become fit to plead and stand trial. However, and this is the main point of disagreement between the experts, Professor Kennedy indicated that the possibility of Mr. Kabuga regaining sufficient capacity to be fit to continue to stand trial cannot be completely ruled out, while Professor Mazie considers it highly improbable that he will ever regain fitness. Finally, it is worth noting that the experts gave the opinion that Mr. Kabuga is very well cared for in the United Nations detention unit and prison hospital, and that he should continue to be cared for in the same manner while he remains detained. Now, before going on to discuss the modalities of the stay and release, the trial chamber would first like to address business that was pending. At the moment, Mr. Kabuga was determined to be unfit for trial, and ongoing proceedings were suspended. First of all, I'm going to look at some pending motions. During yesterday's case management meeting, the trial chamber sought the parties' views on what to do with 4 pending motions related to, first of all, a possible site visit, then a request to admit evidence under Rule 110, a bar table motion, and a motion related to concluding the evidence of Cab 41's testimony. There is also an outstanding confidential subpoena. With respect to the joint motion for a site visit, I'll take these one by one. I turn now to the parties. Mr. Elderkin, before I pose my question, perhaps you would introduce your team to the bench.
Good morning, Your Honours. Good morning to everyone following the proceedings. And today we have, for the prosecution, myself. We have our case manager, Mr. Thomas Logel, Mr. Rashid. We have Maria Yakusheva and Marta Bitorsali.
Thank you, Mr. Elderkin. And Maître Altit, may I accord the same privilege to you?
Good morning, Your Honors. Good morning, Your Honors. Today, Dove Jacobs, and I am Mr. Altit.
Thank you very much. So, Mr. Elderkin, on the first matter, the joint motion made by parties for a site visit, as a result of other discussions, is it correct for me to consider that this should be withdrawn as moot without prejudice to its refiling should the trial proceedings resume?
That's correct, Your Honour.
Maître Altit, do you have any comment to make on that?
No comment, Your Honor, says Mr. Altit.
Various matters will be the subject of a written decision encapsulating all that's decided in the course of this hearing and possibly decided in private by the bench following any submissions that have been made by the parties. So I won't make a pronouncement of that decision, but you can take it that the written decision will contain the disposal of this motion in the terms suggested by Mr. Elderkin. Moving then to the request to admit evidence under Rule 110. Again, Mr. Elderkin, is this a matter that should be viewed as moot and dismissed without prejudice in the same way?
Your Honour, those elements of that, so this is the 110, I'm jumping ahead. Yes, 110 indeed, same way.
Yeah.
And I'll wait for the bar table.
Yeah, thank you. And Maître Altit, any comment on that?
Pas de commentaire, Monsieur le Président.
Maître Altit, no comment, Your Honor.
Now, the bar table motion was the one matter that there were potentially differing views. The possibility arises of admitting certain items from that motion on the basis that the defence has no objection. There was no suggestion that items to which there was objection would be admitted. But even the ones to which there's no objection, do you think there's any benefit in admitting them in the current state of play?
Your Honours, that may well be a matter for your internal assessment in terms of use of resources. I would suggest that it may be considered useful for that admission to take place, obviously without prejudice to there being no further judicial consideration, assessment of weight, use of the evidence as such, but simply to remove that portion of material from any possible future resubmission. So if it's seen as an appropriate way to approach the resources question, then that's the utility. Beyond that, I mean, Your Honour's hands.
Another way of looking at that is that if there is a non-contentious item within that motion, which the admission of which would add to the historical account of events relevant to the genocide, then it might be worth identifying such a document. But at a general glance, from a general glance over the material, most of the material of significance has been admitted in other cases.
Indeed, Your Honour, the public's access to the record can either be through the particular judicial record in this case, or through past history of cases here, even through the prosecution's own publication of materials in its possession. So that would not be determinative, although we did discuss yesterday, I think I put forward the idea that we would like to see as much as possible the fullest possible record in the case, but it's a splitting hairs issue at that point.
Okay, thank you. Maître Altit, do you have any comments?
Merci, Monsieur le Président.
Maître Altit, yes, I would like to make a brief comment. This is, so we think that the decision of the appeals chamber and leads to a suspension related to the funds matter, and we think that this issue should be suspended. This is the question of principle. Now, if your chamber had to pronounce itself of the non-contentious matters, the defense says that because it wouldn't prejudice her, there wouldn't be any particular matter.
I don't think I follow that entirely, Maître Altit. Are you saying that there are some to which you've no actual objection, but that in principle your view is that none should be admitted because of the stage of proceedings that we have now reached?
Oui, merci.
Maître Altit, yes, Your Honor. I would like to specify what I just said. I'm going to slow down a little bit. Thank you, Your Honor. So the aim to admit element is to be able to proceed on the basis of these elements. And because there's a stay, we think that, well, this is how we understand the judgment of the appeals chamber. The aim is to suspend all the acts which would make it possible to move forward. So we think that it is not up to your chamber to pronounce itself today. But because there are matters which are non-contentious, I wouldn't make any further comments. I don't know if I'm clear enough.
If you tell me that, if you tell me that what you're saying just now is consistent with what Maître Jacob said yesterday, then it's clear to me.
C'est exactement ça.
Maître Altit, that's exactly what I'm saying. There are some elements on which we hadn't objected, and so for these specific elements, we have no objection.
Thank you. Now, the subpoena, there is before us, in fact, a written motion. Oh no, sorry, I'm jumping ahead too far. Yeah, before I go to that, the position relating to the evidence of witness Cab 41, who was the witness on the witness stand at the time the proceedings were interrupted, there is actually before the chamber a written motion, and that invites the chamber to release witness Cab 41 from the solemn declaration. Now, is that the terms in which you wish this to be dealt with, Mr. Elderkin?
Your Honour, following yesterday's discussions, it may be a better way to put it to have his testimony ruled complete without prejudice to his recall should proceedings restart. I note Your Honour's comment yesterday about this being a novel application to be released from the oath as such, but if he can be freed from the weight of the proceedings until such time as they may resume, that's the import of what we ask for.
Yeah, I note, having looked at the transcript, that we adjourned the evidence, the witness's evidence, until the next sitting of the court, which was specified. And I then went on to tell him how important it was that he had no discussion with anybody whomsoever about the evidence in the case before his evidence was completed. So you are right that he should be relieved from the consequences of any incidental breach of that. But there's no question here of changing his status as a pending witness. So the appropriate disposal of this will, I think, achieve the objective you seek, but that will be set out in the written order or the written decision we issue following this hearing.
Thank you.
And that takes us to the question of the subpoena and your request that that should be withdrawn, I think.
That's correct, Your Honour.
And that, again, without prejudice to reinstating it should the trial proceedings resume.
Indeed.
Thank you very much. Now, Mr. Maître-Altit, I take it there's no objection to that proposal.
Pas d'objection, Monsieur le Président.
Maître-Altit, no objection, Your Honour.
Now, that's cleared the field in relation to interlocutory business that was interrupted by the suspension of the trial evidential proceedings, and means that we now turn to the two main issues of this hearing. And these are the modalities, firstly, of the stay, and secondly, the modalities of release. And
Your Honour, if I may, although it's not interlocutory as such, in terms of yesterday's sequence, I did also indicate we'd like to request, in relation to the medical report and future ones, access for our experts. So I don't know if it would better sit later.
No.
But it'd be better to raise that. Now, I know that the defence had their position on this, so if that could also be on the record, that we would ask for the most recent independent report to be permitted to be given to our retained expert, and for any future reports from the panel of experts, please.
Thank you. Maître-Altit.
Maître-Altit, thank you, Your Honour. Maître Jacob will answer this question. Maître Jacob. For the defense, what justified the fact that the prosecution could have access to the medical reports and that their experts could have access to these reports was the fact that the discussion was ongoing on the fitness for trial of Mr. Kabuga. So those discussions happened between the parties, but now the situation has changed because there has been a decision on the fitness for trial. So we don't see what is the justification for the prosecution to have access to all the reports for their experts, because the contribution of the prosecution is on the periphery, if I might say, because it doesn't really address the prosecution. So we oppose the request of the prosecution. We would like to ask for a specific request. We have a specific role to play here relating to the release of Mr. Kabuga. So we would like to be able to give the medical reports to our experts so we can all move together towards the release of Mr. Kabuga.
So you're opposed to the release of the reports to the prosecution unless a specific reason is advanced for that?
Oui, dans la mesure où les rapports précédents étaient...
Yes, because the previous reports was given to the experts so that the prosecution could give an opinion on the fitness for trial, but the situation has changed. The prosecution doesn't have to give their opinion on possible litigation, so the prosecution should justify why they want to have access to those reports. And it is not because they had them before that they should have them now. The situation has changed.
In your own position, though, could you be a bit give us a bit more detail of the reasons why you seek to have the reports which the prosecution should not have access to?
Alors, je vais essayer d'être...
I'm going to try to be clear. The position of the defense and the prosecution is not the same at the stage of this procedure, because the defense is active as defense of Mr. Kabuga in order to implement the next stage, which is the release of Mr. Kabuga. This release, to which the defense participates, involves taking into account the medical circumstances of Félicien Kabuga. For the defense, well, I cannot say too much in a public hearing, but in order to be able to implement conditions of release which take into account the medical situation, it is our role as a defense team and to try to find the best conditions of release for Mr. Kabuga with our experts. So to conclude, our position is very different from the position of the prosecution at the stage of proceedings. Our role is very different and justifies the fact that our experts have access to the medical reports.
You'll realize, of course, Maître Jacobs, that the prosecution have a very important interest in an ongoing interest in the case. As far as they're concerned, this case is suspended and not terminated. They will be wanting to keep an anxious eye on the developing medical situation. And no doubt they have not written off the prospect that the evidence may be resumed. So in a sense, does that not put them in a different position from you, admittedly, but do they not stand in the same position as you so far as having an objective which will be informed by reference to the ongoing reports.
Alors j'entends bien
Mr. Jacobs, I understand, Your Honor, that the prosecution hopes that the evidence will resume. And part of this discussion is theoretical, because we believe that this will not happen, because the condition of Mr. Kabuga is progressive and irreversible. But let's say that hypothetically it would resume. If a medical report should indicate an improvement, and if there would be a new litigation, then the prosecution, if it wishes to submit a request, the prosecution could ask their experts to see the report. But today it is very abstract and theoretical. There are no ongoing discussions on these medical conditions. We won't oppose the fact that the prosecution receive these reports, but we do not see the need for the prosecution to show the report to an expert unless they justify it.
Thank you. Mr. Elderkin, do you want to add anything?
Your Honour, I'm glad for the clarification from the defence that they don't oppose us as a party receiving the reports. It may have been a translation issue, but that appeared at one point to be in play. And obviously, as Your Honour noted, we remain a party to these proceedings. The content of the report we have received, everyone here I think has seen. It includes material of a technical, medical nature beyond normal the ability of a layperson to fully understand. We consult our expert to understand what is in the report. That's the process we'd like to continue, and for that reason make the standing request. I don't see there's a need for any greater justification than that, but material of a technical nature that arrives with us is material that we ought to be understanding to the fullest extent possible, and that's what having an independent expert available to us has enabled us to do to date, and that's what we'd like to carry on doing.
Thank you. Again, this decision will be reflected in writing, but we do not consider it appropriate to change the position we've adopted so far in relation to the prosecution expert having the opportunity to see these reports for the purpose of advising the prosecution on technical medical issues. And indeed, we think that the default position should be that that happens in relation to each of the medical monitoring reports over time, unless there's a reason a party identifies for saying it should not happen. And then both sides are clearly experiencing equality of arms in a situation where they have both got interests quite different from each other's. So we'll reflect that more specifically in the written decision. So that lets me now turn to the question of the modalities of the stay. I assume that what's meant by the reference to modalities is that this is not an open-ended stay of proceedings, that the situation will remain subject to the usual rules of the tribunal, and that, for example, status conferences will be required on a regular basis. And the overall situation of Mr. Kabuga's health will be monitored on an ongoing basis, I assume similar to that that has taken place so far. But what I think the bench needs to hear from parties is whether there are any other conditions or modalities that ought to be applied to the order to stay the proceedings. Lay aside the question for the moment of release, but simply the procedural issues that may require to be noticed or dealt with during the course of the stay of proceedings. Now, Mr. Elderkin, have you any points to make on that?
Either happily or unhappily, I'm afraid not, Your Honour. I think the current procedure, status conferences and monitoring is all that we foresee. There may be, as I think again I mentioned yesterday, a need to change the modalities of the monitoring depending on what happens in terms of provisional release. But in principle, those two elements cover the ongoing need for Your Honours with jurisdiction over the proceeding to continue to have eyes on the situation and on the medical side for that monitoring to continue so we can understand what situation pertains to the accused.
Thank you. Maître Altit, yeah.
Merci, Monsieur le Président.
Thank you, Your Honour. Now, generally speaking, I don't have any comments, special comments at this stage of proceedings. Well, when things change, we might have something to say, but for the moment, I think we've covered what is required to be examined with regards to medical monitoring. This should continue, of course, and we agree with it on the principle. There should be continued medical surveillance and monitoring. It's very useful for us. It's useful for the chamber, for the parties, for the defense. And above all, it is indispensable for Mr. Kabuga, because that is the basis on which we can actually determine what the best medical care should be given. It is indispensable that we know, on the basis of what the experts say, where does Mr. Kabuga stand in terms of his health, how is his disease evolving, and what must be done according to the experts. We, of course, think that this medical monitoring should continue, and it is indispensable.
The parties appear to be in agreement that the 6-monthly cycle of monitoring should continue. It seems pretty obvious to the chamber that should continue. Of course, it might be modified should circumstances change or there be developments in the question of release, but we'll face these when we come to them. The only other thing then that we might consider while we're dealing with medical monitoring is whether there should be any changes, modest or major, made to the regime, accepting that it will be on a 6-monthly cycle. Now, yesterday, there was an indication given by the prosecution that they much preferred the format of the report submitted following the latest medical examinations to the one on the previous occasion, which was more succinct. Are there any other points, and that struck the chamber as an appropriate matter to deal with in a connection with the modalities of the stay and how we are to be informed of the ongoing situation. Are there any other things of that nature related to the actual process of medical monitoring that you have to suggest that might be changed, or are you content that for the moment at least we stay as we are? Mr. Elderkin.
It feels a bit like Groundhog Day, Your Honour. I'm thinking back to yesterday and the suggestion that, or the recognition that I made that there may be a benefit in having an additional expert added to the panel who can communicate directly without the need for interpretation, presumably in Kinyarwanda, with Mr. Kabuga. This is not a motion as such. Again, I fully subscribe to the view that this, the independence of this panel and decisions about their composition should be in the hands of Your Honours. But since that idea was floated yesterday, I should put it on the record today for it to be there for your consideration and, of course, for views of the defence.
That's quite right, Mr. Elderkin. I overlooked that. My apologies. Anything else, Ms. Maître Altit, that you wish to raise on that subject?
Merci, Monsieur le Président.
Thank you, Your Honour. With regards to the modalities of medical monitoring regime, we feel that it's too early to basically think of any change and propose changes. We really need to look at this from a pragmatic perspective, depending on how Mr. Kabuga's health evolves, how he's cared for, and it is quite probable that there would be improvements or adaptations to be made in the future, but for the moment I think it's too early to take a decision on this subject. I think that the major point is, the important point is that everything must be done properly for Mr. Kabuga. We will make sure that we communicate our needs at the time come. For the moment, it's too early to discuss about this. Now, with regards to the prosecution's request on the presence of an additional expert, of course, we oppose to this because everything is going well with the three experts for the moment. They have been working with Mr. Kabuga for a long time. They know the file really well. They know the case really well, and they've actually spoken on several occasions. Their expertise, and I'm talking about their expertise was extremely beneficial for the parties and the chamber, and we really don't see any reason, any use of actually having a fourth expert on the panel in addition to the three experts. I think we if the prosecution is going to basically get an expert from Rwanda, we oppose to this because we've had a previous bad experience.
Well, help this bad experience.
Monsieur le Président, je vais être...
Your Honor, I'm going to be brief because this is not the crux of the matter. There was a Rwandan expert who came. He was bought by the prosecution.
Case.
Absolument.
Oh yes, well that's okay. You needn't say no more on this on that subject. We will obviously review that in considering what's been proposed. And I suppose we also ought to look at the 2 weekly monitoring arrangements. We need to be sure that that is also an efficient use of time. Would you be concerned, Maître Altit, if we were to ask the medical medical officer of the detention unit to report to us on what he considered would be sufficient monitoring on an ongoing basis every month or 2 weeks or whatever. What would be best? Or do you have a firm view that we should stay as we are?
Thank you for having us on board on this. We should be, again, working in the best interest of Mr. Kabuga.
Understanding your answer, I'm afraid.
We think that the idea is good in principle, and I can specify that we would like to be informed of these reports from the medical officer of the detention unit, but we also think that there could be some flexibility. So if there is nothing much to be said, there is no need to say anything. But of course, if there are useful things, it's good to communicate.
Thank you. Mr. Elderkin, do you disagree with any of what Ms. Metraltit has said?
Once he clarified, I don't disagree at all, Your Honour. Obviously, it makes sense that the medical officer expresses his views outside the realm of our direct interest. Of course, I assume there is a system for any urgent issues to be directly raised to the defence as a party concerned, and if necessary with the chamber, without necessarily that information needing to be shared with us. So as long as the care situation, monitoring in the sense of caregiving is not changed, then in terms of for the judicial process, yeah, I don't have a strong view which way that should go.
Well, you can take it we have no intention of interfering in the care regime. I am conscious, though, that there are times when not a lot changes in the medical situation, and that routine approach may not be the best now that we are more familiar with the overall picture of the medical problems faced by Mr. Kabuga. So that takes me now to the question of release. Now, this is a priority issue of the trial chamber, and it's going to be the focus of the trial chamber's work in the coming weeks. In its decision, the appeals chamber indicated that the trial chamber should give priority consideration to the issue of Mr. Kabuga's release under conditions that are the most appropriate in the circumstances. It also stated that obstacles to identifying a state that will accept Mr. Kabuga on its territory may not be the basis for his continuous detention on remand. At the outset, the trial chamber is considering release as provisional release as specified in the rules of procedure and evidence, wherein the mechanism retains jurisdiction over the case pending any possibility of the resumption of proceedings. So that, at this stage, is the sole focus of the Chamber's position, Chamber's consideration of this. I think in addressing this, we'll hear first from the defence rather than the prosecution, albeit we recognise the prosecution could, of course, themselves raise this issue in the form of a proposal, but that has not occurred to date in this case. Metralty, the question may arise now of whether we should be in open or private session. I have to be guided by you about that, but the Chamber's very keen that the maximum possible amount of the hearing should be public. One moment. It just it suddenly struck me that we should be operating the regime that we had before the adjournment, and this would be an appropriate time for us to have a break. So we'll hear you on this topic when we return at 11 o'clock. Or, in fact, just to be clear, 11:05.
All rise, soyez vous lever.